Good morning, Will.
Good morning.
How you doing?
Pretty good. I
Good.
thought I was gonna be late, but I see
No,
y'all ain't
you're
started
right on the money.
yet. Okay. Tried to sneak in here all quiet.
This is the second case.
The first case.
Oh,
This
this is the first.
one.
Okay.
I just want you to know that only the top person of the public wants to speak. The other ones do not want to speak.
Okay, just this one on top.
But that's not an applicant.
Yes, it is. This time.
Okay, y'all ready? This meeting of the Escambia County Board of Adjustment is hereby called to order, the date being November 17, 2021. With 5 members present, we have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for November 17, 2021, with Development Services staff's findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
A motion to accept the BOA meeting package.
Do we have a second?
Second.
Motion by Willie, second by Jennifer. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
Reading of the chair will entertain a motion to waive the reading of legal advertisement. Do we have a motion?
Motion.
Do we have a second?
Second.
Motion by Willie, second by Jennifer. Those in favor signify by raising your right hand. Members of the board, have you reviewed the resume and transcript for the Board of Adjustment meeting held on October 2021? Upon your review of the resume and transcript, are there any additions, deletions, or corrections? The chair will now entertain a motion regarding the hearing resume for the Board of Adjustment meeting held on October 2021. Do we have a motion?
Motion to approve the
Motion by
minutes.
Willie. Do we have a second?
Second.
Second by Jennifer. Those in favor, raise your right hand. Passes unanimously. The Board of Adjustment, BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing statements will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because the decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final unless overturned by a court of competent jurisdiction. The county may issue development orders and permits to the issuance of such order of permits is issued. The applicant and not the county shall bear and risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the review court. Any applicant for relief of the BOA for said actions or any aggrieved party as defined by state law may seek review of such decisions by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal for an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk. These forms are located at the table in the back of the commission chamber. You may not be allowed to speak until we receive one of these completed requests to speak forms. We must have these completed forms for public record. All written and oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this provided in Board of County Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. The first case to be heard is conditional use 2021-17 at the address 8625 Gulf Beach Highway. Board members, has there been any ex parte communication regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, and be sworn in by the clerk. State your name and address for the record.
Hi, my name is Shanna Lott. My address will be the 8625 Gulf Beach Highway.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And were you provided a copy of the staff's findings of fact?
Yes, I have.
And you understand all the criteria must be met
Yes, sir.
in order for the granting of the conditional use. But if you'd like to make a presentation of any sorts,
Yes, I would.
proceed.
I have run a dog grooming business in Pensacola for the last 6 years, and I have several customers that drive all the way to Creighton Road. So I have proposed to purchase this property off of Gulf Beach Highway. I'm proposing to open a standalone indoor boarding kennel. It's already zoned heavy commercial, light industrial, so I'm asking for conditional use. The boarding kennel will be Posh Paws Resort, and it's basically going to be an Airbnb for dogs and cats. There was a discrepancy in the size of the property. I submitted a survey that says it's 0.9 acres and not 0.65 acres, which gives us a little bit more buffer room. But it's going to be a standalone indoor kennel. The building size will be 80 by 30, which is similar to the strip mall right next door. It's going to be long and anyways, it'll be 2,400 square foot, about approximately 20 separate kennels. The building will be completely insulated. The kennels will be indoor. I will not have any outdoor kennels. The building will be climate controlled, and the only clearing area needed for the building and the parking lot will be the store frontage to the sides of the building. From the sides of the building back, we would like to keep, it's fairly wooded, not heavily wooded, so we're going to try to keep as much buffer as we can, especially along the perimeters, the 15 to 20 foot perimeter from the side of the building to the back of the property. Let's see. Which would give us a sound buffer at least 15 to 20 feet towards the rear of the property. We're leaving as much of the existing trees that are there and adding any trees and vegetation to any open areas that may have been already cleared. The rear of the property will be, let's see, natural state. Let's see. Of course, we will be planting grass in the rear of the property. So basically, the dogs will be allowed outside between business hours, which would be from 8 to 6. So if there's any playtime or for the animals to go out, it would be between business hours. Let's see. After business hours, pets will only be let outdoors briefly for potty breaks, and only 1 or 2 at a time. We're not going to let them all out to play together, because if you have an issue of somebody else's dog hurting somebody's dog. So whichever dogs are in the kennel, which usually the kennels allow for 1 to 2 dogs, usually a brother or sister dog. So we will be taking these dogs out 1 or 2 at a time and letting them out after hours just for potty breaks, no playtime, no noise, and then let right back into the kennels. The latest would be 9 p.m., just so we can let them out to go to the bathroom before bedtime. Of course, the indoor and outdoor facilities will be very well kept and clean. Any waste will be disposed of properly, and whatever's required for that.
Board members, any questions at this time of the applicant before staff's presentation? If you'll just have a seat.
I have one question.
Oh, you have a question? I'm
Yes, sir.
sorry, Kevin.
Just curious. Yes, sir. Thank you. I'm just curious how many dogs at one time would be allowed, and how would you dispose of the waste properly?
The animals so far we've got it allotted for 20 kennels. The only time there'll be more than, it'll accommodate up to 2 animals per, so say the max would be 40, which would be 2 animals per a kennel. Usually that only happens if the animal has a brother and sister. We won't be putting somebody else's dog in with somebody else's dog. So most of the time it will be a single animal or up to 2. And waste will be disposed of. I have to check with the county as far as the requirements of waste removal. I haven't quite figured out what's required for that. But yes, we'll make sure it's adequately disposed of.
I have a question.
Sure.
This area where they will be allowed to go out, it will be fenced, of course.
Yes, that's what I missed. We are going to put a 6-foot privacy fence from the front edge of the building on either side, extending all the way around the property. So there will be a wood fence, 6-foot privacy fence, along with that buffer of trees and vegetation. Yes, definitely.
Okay. And you said that you are going to do some soundproofing of your facility.
Yes, it'll be completely insulated, which it'll have the walls and the insulation. So it will be a metal building. So I'm hoping we'll have that adequate amount to make sure that you will not be able to hear them very well from outside.
And can you just briefly describe what are your neighbors? Who are the buildings around you?
My neighbors, if you're looking from Gulf Beach Highway at the property, we have currently a strip mall to the right. It used to be a furniture store. I'm not real sure what exactly they're doing with it right now. To the left, there is a very long lot that I've been told that they're putting mini storage. I've been told. And directly across the street is the American Legion. And then within 2 blocks, we have a Dollar General and a coffee shop. Now, the property sits at the very corner of the entrance to, it's the San Marcos Camino area. So we do have just a few residents directly behind us.
And about how far away are the homes? Do you have any idea?
Let's see, the property is 0.9 acres. Each, there are mobile home lots behind it. So we would put the building as close that will allow us to the Gulf Beach Highway, because we'd actually rather have a good buffer. So I'm not sure exactly the distance would be.
Okay, thank you, ma'am.
You're welcome.
I have one more question.
Sure.
You said this is would be used for a kennel. Would you also be a grooming facility as well?
I do grooming now, but I would like to get away from it, so I wasn't planning on it. I did consider offering just baths to any residents, any of the companion animals that stay with us,
Right.
but not necessarily to just the public. So I believe I probably will do that. It probably won't be a full grooming service. It would be just, so the dog goes home clean.
Right.
I have one more question. You said that the insulation that will be applied is not soundproofing, it's an insulated building.
It's an insulated building, but I will, if it looks like it's not enough, I will be talking with the engineers about it. We will apply additional barrier, like walls or whatever needs to be done to make sure that it's not going to be a noise issue.
I'm assuming the Department of Health also has to give you a permit, or there are regulations or something
Yes.
that you need in order to make sure everything is sanitary? and-
Yes, and we will make sure that they come and inspect the facilities and we get whatever is required for licensing.
From looking at the map, it seems like you've got industrial buildings and a vacant lot on each side. The only residences, I presume, is, I think you testified, and it looks from the aerial, that are at the very back of your facility.
Yes,
And you intend to keep as much tree buffering and do additional buffering for that, you're in that area and the rest of your perimeter?
yes. There's actually several large trees, especially towards the back of the property. And it looks like we will be able to leave every bit of that. Basically, all we're gonna go in and just remove the underbrush, but there's several clusters of smaller trees that we would like to leave. And then, of course, there's larger oak trees that we're definitely gonna leave, and a few cedar trees that we're able to leave all that there. Because basically all it's gonna be back there is just a play area, potty area for the companion animals that we're housing. And of course, the 6-foot privacy fence.
Okay.
If you'll just have a seat, we'll call you back.
Okay.
There probably will be other questions.
Sure.
Staff will make their presentation at this time.
Good morning. My name is Kimberly Wilson, and this is the presentation for Mrs. Lott, her dog kennel. The finding of facts as far as this property is located off of Gulf Beach Highway in San Marcos. Okay, we're going to go to the maps. So, we have a location map here. This is the future land use map. And this is the zoning map of HCLI. This is the AIPD map. This is an aerial of the said location. This is our notice of public hearing sign that was put out there, as it should have been. This is looking west along Gulf Beach Highway, south onto the site, east along Gulf Beach Highway. And this is across Gulf Beach Highway from the site, across the street.
The south view is of the empty lot, correct?
Yes.
The wooded shot is the proposed building site.
Yes. Yes. Right there. Right there.
Okay. Okay.
Okay.
I was interested in criteria D when you get there, the last sentence in it, in the findings.
Okay, okay. So we'll start and I'll just go through my findings. So the property is located along Gulf Beach Highway, San Marcos Camino. It's a mixed area of residential uses under the HCLI zoning. To the east is that strip mall, that community center. This particular site is currently vacant. The proposed use for the kennel can be compatible with the surrounding land uses, and as she stated, she'll be required to plant buffering between that site, that single-family site to the rear. And she will go through development review. She's been through a pre-app, so she will go through development review as far as all the requirements with buffering. As far as utility service, necessary water, sewer, per applicant, the facilities and the services will be reviewed at the site plan review process. So she will have to, adhere to the requirements for that. On-site circulation will be sufficient as accessibility to the parcel in Gulf Beach Highway or San Marcos Camino. Required parking will meet the requirements of the LDC through site plan review as well. Applicant also indicates that the facilities will operate only during business hours, as she stated, to avoid any type of noises or nuisances. She's going to try to do that, and she will go through the site plan review process here again. As far as waste, she did state she would dispose of waste properly. And she'll have waste containers will be screened per the LDC if she, or the requirements for the development review process. She will do that as well. Buffering is required, as she stated, at the rear between those single-family dwellings. That will be addressed also at the site plan review process. Signage and lighting requirements would be assessed during the site plan review process as well. She'd have to adhere to the lighting requirements as far as directing inward to avoid impacts to adjacent properties. The size and the topography of the lot, it appears to be adequate to accommodate the proposed use per her site plan and the maps that we have in the aerial. There are no specific use requirements listed for this proposed conditional use. It is listed. So staff did find that the proposed conditional use appears to meet all the requirements and the required criteria. So approval was recommended.
Thank you.
Questions?
Board members, any questions of staff?
I was just interested in what the site review is going to look at in regard to D as it relates to nuisances and the prevention of nuisances. Your last sentence.
If I may, this site's already been through for a pre-app, and I can tell you when it comes to the compatibility stuff, they have 2 separate comments addressing that were given to them. First one, with any commercial site, we've got location criteria. And I know we've been through that on several other cases. This is along an arterial road, but it is over a quarter-mile from the nearest arterial intersection. I believe the closest one would be Fairfield, and that is 1.25 to 1.5, somewhere in that distance. So it would need to meet the site design criteria. And one of the things in that site design criteria falls on buffering from nearby residential uses and zoning. So the residential uses to the south. So that was hit in DRC. That popped up explaining that they need a type B buffer. That is a 16-foot wide vegetative buffer supplemented with either a wall or fence, some sort of opaque barrier as well. When it would come to this one going through, since there is existing vegetation on site, at the development review, the staff's going to push to save and keep as much of the existing vegetation as possible to begin with, and then supplement that to meet the standards of the buffer. So that's your thing, to try to avoid those nuisances. The other ones, the applicant has volunteered hours of operation and hours of outside time. That would be up to this board to look at those as specific conditions you may or may not want to impose. But obviously what's volunteered is already out there.
What's the future land use of this again?
Hang on, I can get it.
It's mixed use urban, I believe.
I believe it's mixed use urban, yes. So it's mixed use urban, which does allow for heavy commercial light industrial zoning. As you can see that from the zoning map you've got a strip running up and down that section of Gulf Beach Highway of heavy commercial light industrial. In many instances, it's immediately adjacent to residential uses. That's a legacy from the previous zoning districts and how they were originally done.
Okay. And one last question. The trees on this property from the aerial look to be mature, fairly large. Will the site review take into account their status under our tree ordinance?
Yes, so could you pull the photo looking south? Generally, in an area like this, the ground is a bit higher along the road there and sloping down from there, because you've got the bayou to the south and you have Jones Swamp to the north. The road is run along the closest thing to a ridge you'd find out there, but it is not high and dry enough that you would find heritage type trees. These are going to be smaller ones, that take advantage of the environmental conditions at that site. But there are going to be quite a few pines back in there, and that's why I said, as part of that review, you'd want to keep as much of the natural vegetation for the buffer as you could, since, no sense in cutting something down to plant something else. I mean, these are already thriving there naturally. Right. You'd want to take advantage of that to the extent possible.
Okay, thank you, sir.
Does the applicant have any questions of staff at this time?
Not at this time.
We do have some speakers, and I will note the names that have signed in as present and are opposed to the project, but apparently they do not want to speak and have designated a spokesman. Is it Kevin Zeidwin?
Zeidwin, yes, sir.
Zeidwin? If you'll come forward, sir, and be sworn in.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Just state your name and address, please.
Kevin Zeidwin, 2555 Granada Communal. Good morning, ladies and gentlemen. My name is Kevin Zeidenwin, and I'm the president of the Bio Grande Villa HOA. I represent 256 homeowners in our mobile home subdivision, not a mobile home trailer park. We pay taxes, we don't pay lot rent. A dog kennel in our backyard is unacceptable. I don't care how you make an effort to subdue potentially up to 40 dogs barking, I think is impossible. If you would show that map of the 500-foot radius, you would see how many homeowners are going to be affected by a dog kennel directly in their backyard. During business hours, when you have a dog kennel, it's almost like a hospital or nursing home. It's a 24/7 operation. I just cannot see 40 dogs going to bed at 9 o'clock sharp and not making a noise. As far as noise installation, by what the young lady said, it's going to be more of a construction like a Dollar General. It's going to be a metal pole barn, maybe with some foam spray insulation. It's not going to be totally soundproof. A 6-foot wooden fence, privacy fence, is not going to stop the noise nor the smell from a dog kennel. Waste. It still hasn't been told how dog waste, animal waste, is properly disposed of. Does it go in a big Dipsy dumpster for pickup once a week? Hopefully it's done on an hourly basis. On the site, I'm not an engineer, but every other construction site on Gulf Beach Highway has had to have a retention pond. Where's that going to be put at? And the last thing is egress on San Marcos. If you're going to use San Marcos to leave that business, you're going to have to go, there's medians there. Do a UE and then get out of our subdivision. Not good. And don't forget the project of 4-laning Gulf Beach Highway. That is in the works, it's going to happen, and that's going to affect egress on that business. Thank you.
Thank you, sir. Just a moment, please. Board members, any questions of the speaker?
Sir, your development, I take it, begins as you go down San Marcos, right? Those are the homes that you're talking about behind the proposed site, right?
Well, yes, sir. Where the pointer's going around, and also even to the east there, we have houses.
So all down St. Marcos.
If you put that 500-foot radius map back up there, I think it's a better indication.
The zoning map, yeah, that was short.
Yeah. It's a better indication of how many of our homeowners, and there's a few of them homes up there that are empty lots or even empty homes. But that's a better indication of our residents being directly affected by it, by the noise and the smell.
And I would like to add, as a director, yes, I am familiar with the site because I've been doing this a long time. That is a well-established subdivision. I'm very familiar with it because I permitted some structures out there in my tenure. So it is a well-established community.
1970 is when it was, the mid-70s is when it was built. Yes, sir.
Does the applicant have any questions of the speaker? If not, I can proceed, and you'll have a chance to summarize later.
Can I comment on some of the issues you proposing?
I can't hear you, but that's
May I
okay.
comment on some of the issues he was proposing? May I comment on some of the issues he was proposing?
Yes, sir.
I have spoke with a civil engineer, and so far, it looks like we should be able to put an entrance and exit on Gulf Beach Highway and not on San Marcos. Also, waste, definitely, I ran my own personal kennels for 25 years, and waste will be removed from the property daily, no matter what the requirements are, just because, like you said, it cannot sit a whole week. Also, retention pond will be to the right of the building. I've already talked to the civil engineer, and he's given me an idea of how big it needs to be, and there will be a retention pond to the right. Besides, we have visited that neighborhood, and there are several people, and seeing how small some of the lots are there are people that already have dogs. I'm assuming they have the same issue. They have dogs that make noise. So you've got a whole neighborhood, and several of them have dogs. So I'm assuming it's a noise problem for them even inside. I mean, I'm assuming they allow them to have it, you know, however many dogs they want or animals. I do want to make sure that the building will be more than just insulated, but soundproof. And I will be working with the civil engineer. And I know that sound may be, but you would have to be fairly close to the property. The only people that may actually hear is the people that are right behind the property, which I'm assuming that would only be the potential problem. But even so, we will make sure that the sound noise is more than adequate. And that's all.
I have a question.
Question?
Yes.
You said waste will be removed and taken care of daily?
Yes.
Okay. How do you, because I don't know, I'm just asking, how do you properly like remove urine from a backyard facility?
We were talking with the civil engineer, and the few underbrush and trees, he was suggesting that we mulch it in place. And what we would like to do is do that, and a lot of it, there were a few cedar, which cedar helps with. We would like to bring in dirt and then put grass. So between the grass, the mulch, the dirt and the mulch should be adequate enough to do away with any urine that is out there. And most of the time, I say the max would be 40, but I really don't think that we would reach max capacity, because most animal owners don't own, they usually own 1 or 2 dogs. But to get 20 people with, 2 dogs at a time, so I'm hoping our max wouldn't be up to 40. More than likely it'd be like an owner with like 1 dog, and then a few with more than 1 dog. So.
Thank you.
You're welcome.
I'm assuming that you're going to service or care for all breeds, and some of the larger breeds. I'm just wondering how that's going to, or will you be able to care for them, but yet not cause a nuisance kind of problem? Do you understand what I'm saying? That when you put really large dogs out in an open space, if you've ever had hunting dogs, you know what I mean. They like to play and bark.
That's initially at the time I had considered doing where they have the daycare for dogs, which I don't know how they do it with, especially when you have dogs that can hurt other dogs, and especially the bigger dogs. So for the most part, I'd rather keep it simple and say somebody brings in a Burmese mountain dog. Of course, you will not be putting two. If somebody had two of them, you wouldn't be putting two in one kennel. They would be in two separate kennels. And if they own just one mountain dog, I would be taking them out individually for playtime, for potty time, and then bringing them back in. So I'm not going to be taking more than, because my fear is somebody's dog hurting somebody else's dog, and I don't want to be in that situation. So I'd rather rotate them to where I can take them out individually, or if they have a brother and sister, they can go out, play for a little bit, bring them back in. And so I won't have like 40 dogs running in the backyard at one time, and I wouldn't have, the big dogs with little dogs, with the potential of, hurting each other or making a whole lot of noise. So I'd rather keep this boarding kennel a bit on the more simpler side, not taking on several dogs, running around the backyard at one time.
Yeah. Well, if you've ever had a blue tick hound or a beagle, then you know what barking
Yes,
is.
I do.
And I know, of course, your paramount interest is the welfare of the animals, and I understand
Yes.
that point. So my question is it, and I probably already know the answer anyway, but I'll ask it, is it absolutely necessary that you have, take them outside?
Not necessarily. That's, within that 30 by 80 building, I will have an indoor play area also. So no, I don't necessarily, if it's a nice day, it probably be more adequate for them to play, but outside. But yes, I will have an indoor play area also.
It seems and I'm just one person up here, but it seems like from listening to the neighbors, one of their real concerns is that animals on the outside, the potential goes up for them creating a nuisance in the neighbor's estimation.
Okay.
So I was just wondering, would it be possible to limit your activities to inside the building? And that's why I asked.
Yes, actually, we could possibly do that. We've already proposed to put a play area inside the building. So yes, we could limit them. Preferably, it'd be easier to let them outside to use the restroom. But as far as playtime, yes, we could definitely just do an indoor play area.
Thank you.
You're welcome.
Now, I would like to say something. She's indicated that she wouldn't mind doing that if the board so wishes for that to be done. It need to come with a motion so we can make it part of the conditional use review, so we can make it part of the site plan review process as a requirement. So I want to be mindful of what you are suggesting, because if you said you got to do it, when it comes to the site plan review process, we're going to put that condition, and it must be done.
Yes.
So that's why I want to.
Okay.
That's why I want to be careful and clear with that.
I have a question for staff.
Yes, sir.
Are there any ordinances regarding sound travel and how much noise can be made? Acceptable noise limits?
So generally, that is something, it's not called out specifically for this use. We do have it called out for other uses. Generally, things, when we start talking about industrial type uses. The only sound regulations in this area are the fact that this area and the platted subdivision there to the south are within the noise zone levels from the Navy base. Okay. Any new structures in that area would require sound attenuation on the inside based on that level of exposure. But, you know, those sound levels shift with the flight patterns. That's under the current regulations. The subdivision, as the gentleman pointed out, so that was platted back in 71, and a lot of the homes that are in the subdivision probably don't have that noise attenuation. But that's really the only noise, you know. Unreasonable is a judgment call,
Yeah.
and we sure can't get into that without actually having something there, so.
Would the board, can the board require sound deadening or soundproofing to a
You-
certain decibel?
I don't see any reason why you couldn't. I mean, once again, we're here for a conditional use. This board is quite able to impose conditions upon any sort of land use approval.
All right, and I have one more question for the applicant. I'm not sure I understood what you said a moment ago.
Come to the mic for recording. Thank you.
With respect to the play area inside and using potty outside, are you saying that you could not only have a play area inside, but that's where they would go to the bathroom? Or would you still be sending them outside for that purpose?
I would probably be sending, for the smaller dogs, we were gonna do the potty boxes. So yes, a lot of it can be done inside. The boys can't quite use a potty box. Of course, they want to lift their leg. So the boys may do better going outside. But yes, we were definitely going to implement potty boxes.
But if this board determined that we didn't want the animals to go outside for any purpose,
For any purpose.
would that be feasible for your business?
It'd be very difficult for the fact that the bigger dogs, the males, they really have to have some way to go lift their leg on something, and I don't know if they can quite do that indoors.
Okay.
Would be basically the male dogs would be the hard ones.
All right.
It would be hard to get them to go potty inside.
Okay,
I
thank
have a
you.
question.
Question?
As far as the male dogs, you know, I own commercial property and have dealt with commercial property and dealt with big dogs before on those properties.
Yes.
And I have, even coming up as a child, had large male dogs, you know, Dobermans and Rottweilers
Yes.
that were inside. But, you know, when you say for the small dogs, a potty box, but what about a potty area? I mean, that's big enough for larger dogs. Is that something that could be done inside?
I guess it could be possible. I haven't really actually thought about it for, like, especially the bigger male dogs. But I guess it could be, I guess it could be doable. I guess the going outside would be the easier way of doing it, but I guess we could come up with something where we had a room that we could let them go potty.
Also, as far as noise, have you ever visited the animal shelter right up the street here?
Yes.
If you go inside, you know, if you
It's
got
pretty noisy.
Yeah.
But outside,
Yeah.
how well can you hear it?
Right, you can't hear it that well at all, honestly. But you know, as far as my concern is, you know, just regular insulation, like, you know, that wouldn't do it. That's for sure.
Yeah, that,
you know.
I've got to touch with the civil engineer. We're gonna work up, I'm not familiar with, you know, I know sheetrock, but, and insulation, but yes, that would be definitely on the high list of, speaking with the civil engineer as far as what we need to do. I mean, even if we had to do like cement block or something more solid, I guess it's definitely on the priority.
Thank you.
I have one other, I guess, question. The real stumbling block I'm having. This is a facility and it serves a good purpose and I'm sure is needed. My chief concern right now is that it just doesn't seem workable from the, generally, when you consider the neighbors' points of view, to have the animals on the outside. I just don't.
They're only briefly on the outside, though.
I know, but I think that's the major, to me, that's the major stumbling block, realistically, because no matter, and I'm sure you will do a, you know, crackerjack A1 job in policing the best you can,
Yes.
but inherently, to me, it strikes me as a difficult thing. But anyway, what I'm getting to would be, would you be amenable to just restricting your activities to the inside?
Yes, we could do it. Back to the point of when we do take the dogs out, it would only be 1 or 2 dogs at a time. Just like the neighbors, if they have a dog, they take their dog out. It would only be however many dogs they own, 1 or 2 dogs. I'm not letting out even 5 dogs at a time. This would be 1 or 2 dogs at a time. But yes, we could try to refrain it mainly inside, most of it. There are several kennels around here, mostly on the other side of town. And I've noticed that they have play areas. Most of them do like doggy daycares. Of course, you know, I don't know what residential, you know, but we do, like you said, we do have the noise thing that we've got a sign seeing that we live near NAS. So we got a noise problem already. So the few times the dogs are going to be let out during the day, and then at night, we can refrain from going outside at all if we had come after business hours. But if it looks like it's going to be a problem, I'm sure we can come up with some way where we can basically keep most of these dogs inside. But like the neighbors that live behind them, there is somebody that has a Rottweiler down the way. I mean, they let their dog out, and so it wouldn't be any more than that, the barking from that Rottweiler, you know, especially during the day. During the day, business hours. At night, you know, we can refrain from taking them outside.
Yeah, I think you make a very good point, and the way I'm looking at it is, I live in a large subdivision, probably have 100 houses around me, and I hear dogs bark all day. Some of them bark at night, and the reason why they bark is because they're left outside unattended, they're bored, they've got nothing to do, and the owners don't take good care of them. What we're looking at here is someone who is going to be attentive to these animals throughout their stay in a kennel. They're not going to be left there outside at night by themselves. They're going to be inside. When they're out playing, they're probably going to have someone out there with them, a person out there with them. So I think we need to look at this in a kind of a different point of view. This isn't a house with 40 animals that runs amok. This is a business where it's her business to maintain the care and health and safety of these animals. So I would say you're probably going to hear more dog barks in the neighborhood than you are going to be in her facility. And that's just me living in a large neighborhood. You have the house with the dog that barks constantly. I have a dog. He goes outside If I'm outside with him, he doesn't bark. If I go inside and leave him out there, he's gonna bark. He's gonna hear something, he's gonna bark, he's gonna get bored. So I think we need to understand that this is a business to take care of the animals, and someone's gonna be with those animals when they are outside. And my concern with restricting her business, and that's totally up to you. I mean, if you want to do an all indoor daycare or kennel facility, sorry, you know, and that's feasible, I don't know how it would be, but if that's feasible, that's entirely up to you. But we also remember we're dealing with animals. We're dealing with dogs. Dogs like to go outside, sniff things, you know, be outside. So limiting her ability to take care of an animal may detract, you know, from your business. You know, my dog likes to go outside. It's a dog thing. So I think we need to understand the nature of what she's trying to do, as opposed to she just wants to own 40 animals, you know.
I have a comment.
Thank you.
I totally get exactly what you're saying. These animals, they do need attention, and they do need proper facilities. I'm a dog owner. We have a dog at our house. It's a small dog, and there's always somebody around with that dog. So that dog does not bark with that. And you know, I don't think it's fair, you know, to compare a kennel to a neighbor having a dog, because those neighbors, their dog go out and urinate and use the restroom, and you can't compare that to 20 to 40 dogs, you know, in one area doing the same thing. I think, you know, as far as noise in the building, that does have to be, you know, really taken care of, because, you know, my concern is, you know, hey, while you're tending to 2 dogs outside, you know, I don't know how is your staff? I mean, how many people's on staff? I mean, who's attending the dogs inside?
First starting out, I'm looking at 4.
Okay. Make sure you got a blue form filled out so you can speak, and you'll have your turn. Yes, sir. But you know, how is your staff? Like, while you're outside with 2 dogs, how many people are inside? And is that round the clock, or just in the daytime or nighttime?
Starting out, we're gonna have at least 4. Of course, you know, as business picks up and we require more, we will hire more. But there definitely be 1 to 2 people outside, depending upon the size of the dog, and 2 people indoors at a time. Like you said, the dog will not be left alone. So say you do have excessive barker, and me or my staff takes the dog out and it just won't stop. Obviously, we're not going to stay outside and just let it bark and bark and bark. We're going to bring it back in. And if knowing that, and I know we have some bigger dogs like the healers and stuff.
That'd be in a perfect world if we had dogs that didn't bark, so I understand.
Right,
yeah.
But you do have a lot of the smaller dogs like to bark more than some of the bigger dogs, with exceptions to some of them. But obviously, if it is a big barker, we would just keep it inside, and we'll give it accommodations for a play area and a potty area. So.
All right, thank you.
Mark, you had already filled out a form. You filled out a form in opposition.
Yes, sir.
And said you did not wish to speak.
I changed my mind.
You've changed your mind?
Yes, sir.
All right, come to the podium and be sworn.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please state your name and address, please.
My name is Mark Skelton. I live in Yokota Air Base in Japan. I have a lot in Bayou Grande. Okay. I really appreciate what she's trying to do. We at Yokota rely on a kennel because a lot of people go TDY, the PCS, and they have a modern facility there that we have kept our animals in. However, I do want to say that inside the kennel, there's a reception area, and in the back they have all the kennels. I would say maybe probably 30 kennels. They have cats and dogs. They're separated, but it is so loud inside that you have to wear hearing protection. And when you bring your dog in there, you feel almost sorry for it because the other dogs start to bark because it's a newcomer, and it is very loud. It's a modern facility, well designed, but it's built in an area that is not adjacent to any housing area on the base there. If that facility was located where it's going to be there, it is loud. And when I go to take my animals there, it's in a location where they have an automotive shop. There's a school bus zone. It's all kind of industrial there. It's not located anywhere near the housing. So I do appreciate what she's trying to do. I just think it's not a good location.
Board members, any question of speaker? Applicant, any questions of speaker? Thank you, Mark.
Thank you.
I will note for the record, Ida Cast and Eveline Skelton do not wish to speak, but they're present in opposition to the conditional use. Would staff like to make any type of summary statement?
As far as if this would, you guys can consider this as far as the number of dogs being out, maybe you would want her to consider limiting the number of dogs that she let out at one time. I don't know how her business is going to be set up. And maybe designating a certain area in the back and not just the entire area for them to, whether they use the bathroom area and then a playtime area, you know, big dog, small dog, just a suggestion. And maybe additional buffering is, you know, if you want to consider that or have that, take that into consideration as far as the outside and the concern with the dogs being outside and the barking outside. As she made a point, you know, it is more so a business. You don't typically have all the dogs mingling together all at once. But that was just something if you guys want to consider that as far as a certain area and a certain amount of dogs at one time, definitely not different size dogs all at once. I'm sure she's going to do that anyways, as she stated. But here again, a certain area for playtime, maybe a certain area to go potty, and not the entire back portion of the lot. Definitely not as far as to the residential, where the residences are.
And I would like to add, and staff does understand the adjacency to the community. It's a well-established, and I say that again, staff does. So so board members, this is, because see, this is what happens. Many times when neighbors remember what you all say, but if it's not specialized, if it's not really understood as a special project conditional, when it go further, it's not going to move further. But so what they'll do is, well, but Mr. Jones, the board said, then they'll start calling me. How come they didn't do that? How come they didn't do this? So if those are the concerns, it need to be stated explicitly what you expect from her. And then when she comes to the site plan review process, if she cannot meet those demands, she may have to find her another location, because it is adjacent to a neighborhood. So you really want to manage expectations of her so the neighbors can know what to expect as well. And then my DRC staff, when they start coming to the site plan review, we can say, well, you stated this, you stated this, you got to make accommodations for those things. You're going to have to have all inside. You're going to have to have those certain things that you all are concerned. If the noise is an issue, that's one of the conditions that you don't have to vote on as a denial. It is. So because the neighbors, they did raise some valid concerns, but it does meet the requirements basically at this time from staff perspective. But some valid concerns, and she appears to be reasonable to some of those things on the same side. I just don't want her to overpromise something that she cannot deliver as well. Ms. Bass made a very valid point. This is a business. The site is, you only got so much to work with. When you start putting this parking, stormwater ponds, those things require space as well. You gotta have handicapped parking. So all of those things. So I want to be able to manage the expectation, what the neighbors want, need, to satisfy, to make accommodations, and to manage her expectations on what she can do and what she cannot accommodate.
Board members, any questions of staff? Does the applicant, would you like to say any more in a closing statement?
No, I think we've covered.
Thank you very much. Board members, any questions of staff or the applicant? Seeing none, the chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt the staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address each one specifically as to why you do not concur with staff's findings. Do we have a motion?
Mr. Chairman, before we get a motion, I'd like to just discuss some items that I would like to get the board's reaction to. Let's assume for the sake of argument right now that someone moves that we approve this application. I myself would like to see, we've had a very good suggestion from the staff about segregated, and I'm speaking of the outside issue for the animals. We've had, in my opinion, a good suggestion from the staff as to having a segregated play area and bathroom area. That seems to me to be a reasonable thing. We've also had a discussion, and I think is well taken in my opinion anyway, on requiring soundproofing. And the last thing that, and this is strictly my thought, is that the applicant said that the last time the animals would go out would be around 9 o'clock. I think that is a little late just in my opinion, and I would think that we would want to see some time earlier in the evening than 9. And those are and also that we would ensure that, as the applicant stated, to my recollection, that there would be a limited number of animals out on, during this time. In other words, you wouldn't have all the animals out together, that they would be taken out in shifts, or, well, I don't know exactly how to phrase it, but those are just some thoughts, and I would appreciate the board discussion, or if any of those merit anyone else's opinion.
I have the same concerns that you do, and I think the rest of the board has. My problem is the number of restrictions or requirements that we would have to put on the owner to control those problems. And that just leads me to believe that, I mean, the owner could promise to control the number of dogs going outside and the time, and could soundproof the building, hopefully accordingly enough that no noise escape the building. But I think though those promises can be made and we can put those requirements in this motion, it just leads me to believe that there's too many things that could go wrong after construction, and that leads me to think that this is the wrong area to have a kennel.
I'd like to add something to that. I feel like sound barrier, soundproof walls should be a requirement because it does get very loud when you get 20+ dogs in a room or a building together. As far as restrictions, I think she stated that it'll be 2 dogs at a time going out during those hours. And as far as that, with me being a dog owner, my dog goes to bed at 7:30 every night, but I don't expect for everybody else's to do so also. You may have someone that come to that Airbnb dog kennel, or and they may work the night shift, and the dogs may be on a different well, they may work day shift, and the dogs are on a different schedule, around the house. So we have to take that into consideration. I feel like 2 dogs at a time would be good during those hours that are committed. And then you may have 1 dog that may be just causing a ruckus in the middle of the night because he has to use the restroom. And I feel like either that indoor bathroom facility should be used at that time, or that dog should be allowed to go and use the restroom. So we don't want to, abuse the dogs by applying all, these strict rules, because there are going to be some times when you may have to take a dog, he might get sick and he may need to go out and be washed or whatever may happen until his owners arrive. But I'm all for soundproofing that building. I mean, that is a must. I mean, because as an American, I feel like you do have a right to be here and a right to open your business, but we have to be respectful of the neighbors, the people that's behind it, that have paid their taxes and paid their dues, in that neighborhood. As far as buffering, maybe we can add a few more feet onto the buffering where it needs to be. The trees need to stay. I think it's 16 feet. Is that correct, staff?
I think that's what they say,
The
yes.
buffer zone. Maybe we can add, 4 more feet, 20 feet. Hopefully that'll help the smell from blowing over. Because it is not the same when you have 1 dog in your yard and he's urinating year round, and versus 20 dogs urinating year round in one section. So we do have to consider that. And you as a business owner you have to be responsible to make sure that cypress is continue to be refreshed as needed, and not trying to save a buck. And it wouldn't be fair to the neighbors. So I do agree totally 100% that you do have a right to put your business there, but you also have to respect the neighbors, and really should consider in order to do that, having soundproof the whole place, and make sure those dogs maybe have a designated area of using the restroom closer to your building and not closer to the buffer zone, you know? And that's how I feel about that.
And let me suggest something too. I think when it comes to the designated area, you bought, so you want to save some trees. You want to save more trees, want to use the natural vegetation. So therefore, again, when it comes to the site design, you never know what you're going to discover and come up with. That's why I like the broader based comment soundproofing instead of, because when you start designating areas, if stormwater is an absolute must, absolutely. So they may need to do more when it comes to stormwater, where they may have to take up that designated area. So basically requiring more buffering, then they know what they got to work with. They can work within that, and if they cannot do it, hopefully she hasn't bought this lot.
We go to closing Monday.
So enhancing buffering, but putting designated area, because you never know that designated area, what it's going to impact during site construction. But enhancing, this what you gonna have 20-foot, you gotta keep that, and everything else you can work with. Because the builder we may have to take variance on setbacks and things like that, because you gotta be set back from property lines. So all of, and parking, ADA is absolutely mandatory. So those are the things, enhanced buffering, but designating certain areas and requiring them to do that, when she may not be able to accommodate all of that. But protection of the neighbors and making sure of peaceful enjoyment with them is critical. It is adjacent to this neighborhood. I want to say that again. It is adjacent to a neighborhood. So reasonable expectations, something that she can work with, because the site is not that large. Isn't really, but enhancing buffering 20 feet or more and the soundproofing, that appears to me, from my point of view and understanding site plan review, that appears to be more logical at this time, based upon the desire to keep the natural vegetation, more of the natural vegetation on site.
Jennifer, did you want to make a comment? Let me just say that, to me, Jennifer's synopsis of what we're about was right on target.
Absolutely.
And I think we have to be very careful about trying to manage a project. And at this point, I would say that we have two options. Well, we have plenty of options, but the procedure could be that we vote on a motion whether to approve or not to approve, and then address any amendments to the motion if one feels that it's a critical, important amendment. But I think we're getting into a fog here, and this came up after we asked for a motion. So, more discussion?
I think, I agree with you. If we had a motion to approve this, at this point, I would say no. But that doesn't mean that I wouldn't, if I was outvoted, I would still want to have discussion with what we could do with amendments in order to correct or control those things that I'm concerned about.
Okay. Here again, I'll repeat, the chair can entertain a motion to approve it, or you can add a stipulation or amendment up front, or await the motion or the direction on the motion to approve. So again, the chair will entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address each one specifically as why you do not concur with staff's findings. Do we have a motion?
I'll make a motion. I make a motion that we approve staff's findings of fact. I would like to add a caveat of soundproofing. I'm not sure how to quantify. Yes, I want soundproofing, but to which degree? That, I think that's where I'm kind of concerned at. How do I quantify how much soundproofing?
So, yes, ma'am. I'm Caleb McCarty, planner, Escambia County. I would say specifically to some of those adverse off-site impacts, the LDC in Chapter 5 does deal specifically with times and decibel levels concerning what this would be a commercial type of use. It essentially defaults to the county noise ordinance.
Okay.
But there is a table for specific uses that say between the hours of 7 and 10 p.m., it can't go over a certain level of decibel levels. I believe it's like 70, 75, which is typical for these type of uses. So something such as that may be where you want to go to not exceed those levels. In particular, the amount of dogs or whatnot can go outside working hours or something along those lines. But it is listed in the LDC Chapter 5-9.2, does deal with that.
I think that's acceptable. And
I'm sorry. I'm sorry. I may be able to simplify that for you.
okay.
Okay, I had mentioned that that whole area is within noise zone from the base.
Yes, I thought about that.
Okay. So now remember, soundproofing works both ways. Okay. When you're talking a noise zone around the base, it's soundproofing so that the inside isn't getting the extra noise as opposed to the outside. Once again, it works both ways.
Is that typically roofing, though, whenever we're talking about things of that
We
nature?
don't have that in our code. It's in the building code.
Right.
And how it's reached. I'm only bringing this up because, like I said, the majority of the existing subdivision to the south, they're in the 65 to 70 day-night level noise exposure area. And our code does say an interior noise level reduction of at least 25 decibels is required for residential or educational facilities and is recommended for other noise-sensitive uses. So that, I mean, that's a
Right.
standard that maybe that would help.
Right.
Just a suggestion.
Yeah, no, I agree, and I understand.
It's quantifiable, that's predictable, that's measurable, that's a good point you made.
Right.
That's measurable, it's quantifiable, predictable. You
And-
can, if it exceeds, code enforcement say, hey, wait a minute, it's a because this is a noise sensitive. So that covers that, that's a
And-
very good point.
And if the noise levels change and shift, well, it's already built to that standard.
So, basically, as long as she builds to code, then we're good.
Like I said, it's very close. Where the noise contour is drawn, she's
Right.
just on the outside. She's in the lowest level that doesn't require
Right.
that attenuation. Just over the line, and we're talking 100 feet. So, I mean, with noise, obviously, that's.
Right.
That the rest of the subdivision is, though, that level, the between 65 and 70 day-night level is the one that calls for the 25% reduction.
So,
If she-
we could require her to build to that level.
Yes, if the building was being built 100 feet south of there, it'd have to reach that
Right.
anyway. So, and no, I don't know how to word that.
Yeah, I appreciate that.
Sorry.
Ms. Lott, what do you understand what we're talking about as far as right now, your noise level that you're in is such that you don't have to meet a certain decimal level. If you shifted your building 100 feet or 200 feet, you would have to build to a certain code, if you will. And I'm sure that means more money to do things, you know, it costs money to do anything. I don't want to impose on you something that you don't know financially what that means. And that's my reluctance on saying you need some sound proofing versus you need to meet a certain level of noise canceling, you know, building. What is your thinking? Because you're the one that's going to have to build it, and I don't know financially how much that's going to cost you.
Right.
That could make or break a business.
Well, basically you were saying if I was building the code, it should fall in within those ranges, right?
No.
No, it wouldn't.
It would not.
It would not.
Because
Okay,
of where
that's-
your property is located.
Oh, I see, okay.
Now, if your
so-
property was located 100 feet to the south, is it?
Oh,
Then,
Couple hundred feet, sorry, I
Couple
just measured,
hundred
it
feet.
is, yeah. But, so you're in the lowest level of sound contour.
okay,
If you were built further south where the majority of the subdivision is, anything new structures coming in that area would have to have this 25% reduction. So that's,
right, yeah. So what I am suggesting is making a motion that you would have to comply with the more stricter sound. Help me out.
65 to 70 level,
Yeah,
decibel
the
level.
65 to 70 level, decimal level for your building.
okay. So basically, I need to get with the engineer and see where that puts me and what would be required to do so.
Right, right, and then that's my concern is, if I make the motion, then you're stuck with it. But does that mean that's gonna cost you $10,000 more, or does that mean that it's gonna cost you $100,000 more? I don't know that answer.
Yes.
But I know that, you know, that obviously it's gonna take something more than just, you know, the metal building and
The
the
existing.
insulation and sheetrock.
Okay.
That seems to be the biggest holdup, I think, in general, is noise. And I mean, when I was a kid, I used to work at the Humane Society. I volunteered there. It's very noisy, way back when. So, you know, it can get noisy inside of a building. And I'm sure y'all have to work in there, so to a point, y'all don't want it overly noisy as well.
Right.
So that's kind of where we are as to stipulating some type of noise restricting structure, if you will. Chairman, what do you recommend? I mean, what we're asking of her is a financial burden that she may or may not want to partake in.
I think she would have that option. I think the number one thing today is approve or disapprove of this use, so that she'll know where to go.
Okay, I'm going to go ahead and make a motion to approve the use, to approve the staff's finding of fact with the requirement of increasing the sound to the 65 to 70 decimal level.
Mr. Chairman, I'll,
65 to 70 aviation noise contour,
Aviation contour
noise,
noise
sorry.
level.
Okay, we have a motion on the floor.
Mr. Chairman, I'll second it with also, would you be agreeable to, instead of 9 o'clock, to have your last go-out session with your animals to say 8 o'clock? Because there are, I would estimate, probably some individuals who would want to go to bed before 9,
Yeah.
especially if they're elderly.
Absolutely. The only reason I said 9 is because I thought that, like he said, the noise level is between the hours of 7 and 10. So I was guessing 9 o'clock would be the latest because that's within the 7 o'clock a.m. to 10 o'clock noise levels. But yes, definitely doable. And I do like the idea if much more buffer in the back and making a smaller play area with segregated, which is definitely doable.
Mr. Chairman, I would add her two suggestions considering the segregation of the play areas and the additional buffering, and I will second the motion.
Excuse me.
You want to quantify that? The reason being because, see, we know we got 16.
Well, I thought.
16.5 can be, so we need to, I like to be predictable for my staff to know what to expect.
Well, it's my understanding that the actual decision on those things would be made at the DRC.
Yes, but we only require 16 per se.
Excuse me.
So whatever that requirement is, our requirement is set. I think they said like, how much they said, like 16. So if you want additional, how much? A number, we need a number.
Excuse me. I was thinking additional 4 feet would be not asking too much or too little. That would make it kind of fair down the middle. Do you agree to that, sir?
That would be a type C buffer. Currently it's a type B. A type C dedicates it to a 20-foot buffer, and also the applicable trees and shrubs that are required. Now, the existing natural vegetation may be implemented, but a type C buffer would be the proper terminology.
Mr. Chairman, I'll amend my motion to include the type C for specificity purposes.
Okay. We have a motion by Jennifer, a second by Michael. Any further discussion? Seeing none, those in favor signify by raising your right hand. 1, 2, 3, 4. 4 yes, 1 nay. Motion is approved as stated.
Thank you.
Drew is a professional writer of motions, so he will add that. Do y'all need a 5-minute break? 5-minute break, thanks.
with our blinking, blinking,
Screen.
screen?
It was, we tried unplugging, like, it was happening before I came in, when we tried unplugging them and plugging them back there,
They're off now. Now they're, some of them are off and some of them are on.
Yeah, there was a power outage. That's what, when the sound went out
Yeah.
and all the screens went out, including that one, that was, the power back there went out. It was still recording, thank goodness, but you had to reboot them.
Something happened at the commission meeting too yesterday that, you know, the screens, I was watching online, kept going on and off.
Yeah, I'm not sure what it is. We went through that at the house, and the Wi-Fi was going in and out
Yeah,
all
right.
day long.
Yeah,
Solar flare, maybe?
I don't know. I guess if you pay AT&T, they'll keep it on. I wouldn't mind getting a Coke. You all ready for Thanksgiving?
No. Well, yes and no, because the nonprofit that I founded, we feeding families like the elderly in the community.
Yeah.
Some that take care of some of the foster kids.
Right.
And and then we're going to Baker, Florida. I had agreed to do a catering for women's shelter. It's called Saving Grace Women's Shelter. And I was like, okay, a new nonprofit, that's awesome. They got 21 women. And when I agreed to do it, I thought they were in Santa Rosa,
Yeah.
but they're actually in Baker, Florida.
Yeah, Baker is a long way
Yeah.
from here. I went to Baker once, but it was closed.
Yeah. So it's like, you know, I gotta rearrange my whole Thanksgiving plans, which is fine, but it just, you know, we got so much to do.
Have you had any trouble buying turkeys?
Yes, yes. We were hoping to get some donated, and so we had to resort to, we got Sam's to, they were supposed to put 50 rotisserie chickens to the side for us, and because we're having trouble with turkeys, and so now they only put 15 to the side. So now we're like forced to go. We were putting those in place of some turkeys to keep us from having to buy so many. Now we gotta buy more turkeys, so that's the issue now. So it's like, that's what I mean. We ain't ready, but we gonna do it.
Well, I'm gonna go and see if I can get a Coke.
All
Well, we're going into session here.
Yeah, you're fixing it up. Well,
I tell you what, this board is like a box of chocolates. You never know what you're gonna get, open up, you know?
That's good. That's pretty good.
She got me to thinking down there. I was like, oh, poor baby.
That's always tough to amend.
Yeah, yeah, especially when you get really specific in particular to someone's, you know, I'm gonna tell you how to run, you know, in general,
With setting limits and technicalities.
yeah, that's just really hard.
Well, that would take longer than that.
Yeah,
You just never know what
never know.
it's gonna go.
That's gotta be annoying, sorry, guys.
You're all right. We catch it. That's that unplug and replug, right? There you go. Very good, very good. Yeah,
Rebooting.
yeah. I do it all the time with TV.
There's no more boxes. I'm sorry. Okay. That's it. Okay.
The Escambia County Board of Adjustment, November 17, 2021 is back in session.
We're missing some staff. We're missing some staff.
You need help over there? I think I'll be all right. I thought, that's the reason I went ahead. Show them you can do it without them. You want to wait for them? No. I thought so.
So, yep,
The case is variable 2021-07, 16411 Interarity Point Road. Has there been any ex parte communications regarding this case, board members? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none, does any board member intend to refrain from voting due to a voting conflict of interest? Would the individuals who are party to this item please come to the podium, identify yourself, state your name and address for the record, and be sworn in by the clerk.
My name is Jim Wilson.
There you go.
Try again. Okay, my name is Jim Wilson. My wife Judy and I are residents at 16411 Interarity Point Road, 32507.
If you both want to go ahead and raise your right hand, I'll do it at the same time. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
We do.
Thank you.
Now, did we get your name and address? Oh,
Larry Skopecki, South Bay Construction, the acting agent.
thank you. Were you all provided a copy of staff's findings of fault?
Yes, sir.
Do you understand all the criteria must be met in order for the board to grant a variance?
Yes, sir.
Would you like to go ahead and make a presentation?
My name is Jim Wilson, and I'd just like to respond to a little bit of the staff evaluation. Let me start with criterion 1. Says the staff found that it does not rise to the level of a hardship in use of the land as designed. In terms of putting a home on the lot, the home is already there, so it's hard to argue that point. But the problem of it is that I cannot use the land or the lot in terms of a home that is more suitable for me than it was for the person before me. It has an extremely small garage, and I can't even get my cars in there without risking scraping them up because it's a very narrow garage. And I have a truck that I can't get in there at all. And in addition to that, I have no workspace. So that's the only reason for asking for addition to a garage that requires a variance, because of the reality of what I'm dealing with. It's just simply not usable for me. I think it was fine for the people that was there before, who maybe only had one vehicle, but regardless. In criterion 4, it says the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. And if I understand this right, basically, it's basically saying that, well, there's a house there already. But there again, I don't have any room for the vehicles that I have, much less anything as far as a usable workspace for me, or storage either, for that matter, because I have no storage in this house. I like to put a lawnmower or utensils and stuff like that. Let's see, in criterion 5, it's again, it's kind of the same thing. There is a house there, but it doesn't accommodate our needs as far as having enough space there. And part of the reason for this whole deal is I don't have the option to build anywhere else on the property. The HOA requires that anything that we add to the building has to be attached to the building. So I don't have the option to go somewhere else on the property and build. I really don't have anywhere else to do it. And because there's a green space beside of us, there would be absolutely no injury to anybody else. And I'm not asking to build outside of my lot to infringe on anybody else's property or anything like that. It's just, I know because of the green space, I'm not going to be injurious to any neighbor that would say, oh, well, you're too close. It's not like we can build something and we can reach out and shake hands with the neighbor. We're not asking for anything like that. I've already talked to the architectural committee, or a representative for the architectural committee for our HOA, and they don't have any issues with it. So I'm confident that that's not going to be an issue as far as any of my neighbors is concerned. And if you have any other questions now or later, we'll be glad to do our best to address them to your satisfaction.
I didn't understand. Tell us again what the architectural board at the homeowners association said what?
The requirement for the architectural committee or for the HOA is that if you build a garage, it has to be, or a workspace on the property, it has to be attached to the building. And basically what I understand that to mean is they don't want you going out and buying one of these little prefab buildings and putting it in the yard. So the only option we have is to add to the home that we already have. And I already mentioned that we wanted to put a garage here to one of the representatives from the architectural committee, and they said they didn't see why that would create any problems at all because we're not infringing on the green space that's beside of us. And you'll see that better when they show the pictures. And, okay?
Okay, thank you, sir.
Any other questions?
We'll let staff make the presentation, then would you like to say something before they present?
Just to kind of maybe give a little better rundown for it. So what we want to do is add another garage to the property. The current garage that is there is of minimal size, basically 20 by 20 to the outside, leaving 19 foot plus in each direction on the inside. This is being built out on Innerarity Island. The restrictions out there do not allow us to do a detached structure. So any structure we build must be attached to the house. And in doing so, once we attach to that house, we now have to meet the setbacks of a primary structure as opposed to the setbacks of a detached structure, which would allow us to go beyond the primary setback lines. So that's what we're here for today, is because the HOA out there, the covenants of that lot do not allow us to do a detached structure, we must connect. And in order to do that, we need the additional footage. If that makes sense.
I'm sure I missed it somewhere, but what is the square footage of the house?
It's about 2,600 square foot.
2,600 on the square footage of the house, but the garage that is existing is just barely above 400 square feet.
Living area is 2,600?
Correct.
Thank you. Staff?
All right, so first up, we're gonna have our location map showing the property off of Innerarity Island. Our future land use map, it is mixed-use suburban. Our 500-foot radius zoning map showing the zoning of low-density residential, LDR. And this is an aerial map. Obviously, what looks like unopened right-of-way there is the greenway, essentially, that was platted, and that will go in the findings. Here's our public hearing sign as posted. This is looking on the site. Obviously, there's the house there with the driveway, and the proposed addition would be approximately where the car and attached to the house there. This is just a photo of the house. And this is the adjacent property, otherwise known as the Greenway, that is to the west. Just another detail of that area. This is looking west along Innerarity Point Road. This is looking across the street. There's another single-family dwelling. And this is looking east along Innerarity Point Road. That concludes our photographs, and if you'd like, I can proceed into our staff findings at this time. The requested variance, of course, the applicant is requesting a variance to reduce the side setback for the construction of addition to a single-family dwelling. Concerning criterion 1, special conditions and circumstances, findings and facts show that there are special conditions that exist which are particular to the land. On the recorded plat for this subdivision, a private greenway is shown immediately to the west of the subject property. At the time the subdivision was recorded, it appears that the streets, roads, and greenways throughout this subdivision were private and remain private today. However, several properties in the area abut the greenway as well. The parcel is similar in shape and size of the properties in the surrounding area. Staff found that this does not rise to the level of hardship in use of the land as designed. We do have Exhibit A that we can look at shortly. Concerning criterion 2, special conditions and circumstances do not result from the actions of the applicant. Findings show that the lot was purchased as platted. The desire to reduce the setback for the addition is the action of the applicant. The side setback requirement for principal structures in the LDR zoning district are 5 feet or 10% of the lot width at the street right-of-way, whichever is greater, but not required to exceed 15 feet. This lot is 100 feet wide, resulting in a required side setback of 10 feet. The applicant wishes to reduce the side setback to 3.2 or less if allowed. Criterion 3, we found that granting the variance requested would not confer on the applicant any special privilege that is denied by the Land Development Code to other lands, buildings, or structures in the same zoning district. A grant of relief from the setback standards of the LDC can be requested through discretionary review of the Board of Adjustment and is available to all. Concerning criteria 4, findings of fact show that the strict application of the provisions of the Land Development Code would not deprive the applicant of rights commonly enjoyed by properties in the same zoning district under the terms of the Land Development Code and would not create an unnecessary and undue hardship on the applicant. Concerning criterion 5, findings of fact show that the requested variance is not the minimum necessary to make possible reasonable use of the land. The lot was platted for a single-family residence to be constructed within the setbacks, and that was currently on the land. Concerning criteria 6, the granting of the variance would not appear to be injurious to the area or otherwise detrimental to the public welfare. The greenway would not be impacted and remain open. Staff recommendation, we find that the requested variance did not meet criterion 1, 2, 4, and 5, and denial of the variance is recommended. I would state, just for clarification, what we're looking at here would concur with the applicant and the agent. The required setbacks for principal structures in this zoning district is 10% of the front lot width. This lot is 100 feet. 10% of that is going to require it to be 10 feet. So anything that's attached, part of the footprint of the home, additions, those type of things. It's got to be 10 feet, right? Detached accessory structures, such as a detached garage, pools, those type of things, they're limited to the side and rear of properties, and they only need to be 5 feet. This is not a detached, so that's not something, we explored that, but unfortunately, they have some restrictions with HOAs that wouldn't allow them to detach this, and may make it a little bit easier to get that through the review process. So we're looking at an addition to the principal structure, and that's what we consider it as. Administrative variance, which we process on a daily basis, could have been requested to reduce them down to 20% of the required 10, which would get them down to 8 feet. That's done and recorded to clerk of courts and would need this board for approval. The request is to go further than that. In the applicant, from what I understand, they want to try to get as low as they can. From the submitted site plan, we're looking at about 3.2 feet. And unfortunately, we just don't have a mechanism that staff would be able to approve beyond, going through this board for that requested variance. To reiterate, we did not find this to be injurious. There is a private platted greenway and is dedicated in the subdivision, but we just don't have a mechanism or found that, there was any type of substantial hardship for this addition to the home, to summarize.
Is there a plot map with the
Yes, there's a
footprint of the house on it?
Yeah, there's a site plan. Rachel, if you would pull up the submitted site plan. We do have some additional photos that the applicant provided as well.
Perfect.
This is the proposed addition, right there showing approximately 3.2 feet towards that greenway. The greenway would be to the left side of the photo.
The X portions, that's the driveway?
Yes, I believe that to be the driveway and sidewalk and stuff, yes.
And on over where that rectangle is on past that, that's the greenway we're talking about.
That would be the greenway of the subdivision, yes, the wooded area. Mm-hmm.
And there were a couple of other pictures that were submitted too?
Yeah, of course, here's the front of the house, and, the greenway is going to be on the right side of the photo, those trees and those type of things. That's what the property is abutting there. And the applicant provided us this good photo. This kind of give us where this thing's going to go in that area on the screen.
Where would the garage go in there? Where it says backyard, I guess? Where would that be?
There where they're moving the cursor, the green space there on the side of the home, basically there where you see the fence would be, just before that would be the front of the garage. Working back to the back of the home would be the back end of the garage. So the side yard there where the grass is where the proposed garage would go.
Okay, in other words, the front of where the gray car is, that fence would come down, and then you would be extending back in the backyard, right?
Correct, to the back of the home.
Yeah.
You see where the downspout is? That's the southwest corner of the house. That would be the corner where the garage connects to the house.
And on the left side, can you approximately show how much setback would be left if the garage was built? Would it go to the fence or?
Approximately 3 feet between the garage and the fence line.
You see the garbage can there?
Yeah,
Just kind of project back a line from the front of that can. I'll give you roughly where that setback would be.
It would be, it would be assumed that the fence would be approximately the property line, but it's probably not exactly on the property line. It'd be close to
The
it.
site plan up, it does show the fence.
Okay, okay, excellent.
so the fence is on the lot line then,
It is
right?
on the lot line. Actually, I can't read the numbers, but it's a little bit on the property
A
side.
few inches in, a foot in
Yeah.
or something, so. And just of note, we don't consider that the Greenway would ever be, developed or anything like that. It is platted as is, it's dedicated as private as are other things throughout this subdivision, so just to make that a note.
Is staff aware of whether or not other homes have built up to the greenway?
We looked at that. I didn't see any other type of variances within the area as requested. We did, we always do a preliminary search, and we didn't really see anything pop up. So,
This greenway doesn't have anything to do with a recent or not so recent acquisition by the county of the conservation area that they've created on the island?
No, sir. No, sir. Yes, that was all north of there in the interior. The county vacated portions of plats that included the greenways, but that was all north of this area.
Okay,
Turned everything into conservation.
okay.
And I don't believe that greenway can be developed, and Caleb, you can correct me if I'm wrong, but it wouldn't have enough road frontage to become a lot.
yeah, I think it's, there might be a dimension on there. It would definitely have to be widened if there was, proposed road, but again, it's private. So there's nothing in the county's plans that we're gonna build a road through there. It's platted as private. And to concur with Mr. Homer, I believe that was a separate phase or a portion of another phase,
There's-
a few streets north there.
There's multiple subdivisions that are part of the overall development on the island. Multiple different plats.
Right.
And this is completely separate from all of that.
And this is owned by, the greenway is owned by the homeowners association then, I presume?
Correct.
Okay.
And the greenway does go along the side there, the left side and the rear. So we are buffered between any neighbors.
Right.
It's almost
Yep.
like it would be unopened right of way. It's just a buffer really between these properties and any other ones and other.
It's not landscaped or there's no
sir,
walkways or?
It's just woods. It's
And there's probably restrictions that, the county would never enforce because it's private. There's probably restrictions and things like that in the covenants that's enforced by the HOA. Can they develop it, X, Y, Z? More than likely not, but it wouldn't be anything that we would entertain on our side because it is private.
Would the county require a written authorization from the HOA that it would be acceptable to them to impose this structure?
Not necessarily. Our land development code says, regardless of county approval, it is the burden of the applicant to seek any other federal, state, local, particular HOA approval. So regardless, if we can approve something, that's on the burden. We run into that from time to time. It's on the burden of the applicant to get that approval if it's needed.
Does that mean that the county staff would not require HOA
We would
to
not.
tell you?
No, we would not require it. We can't require it technically, and we
Okay.
wouldn't, so.
But we do have to submit to the HOA our
This
set
would
of
be my
build
next
plans, this is just step one.
All right, and obviously, if they said no, you're stuck right then and there.
100%. Even if you guys approved it today, if the HOA declined it, we would be stuck at that point.
Yeah.
And that does happen. The county may approve something, the HOA not, or vice versa. We do like to be on the same page, but again, we can't control anyone.
I don't mean to redesign your structure, but is there any possibility of moving the garage to the back of the house, still attached to the house, and leave that?
No, because we still have to attach to the house. So at that point, we have to meet the primary structure setback still that we're fighting on the side, still apply to the rear yard.
Okay, so you would.
So once we attach to the house, it's just a totally different set of rules. If we were playing by the detached structure rules,
No, I meant still attach it to the house. If you move it around the corner, is that causing a problem?
we wouldn't be able to
Design-wise?
occupy it with cars or anything like that, and would be a large extension of the driveway, and of course, remove what is left of the rear yard. So what is not shown on this site plan currently is there is a pool in the rear yard.
Okay.
Could we take a look at the pictures again? Our pictures, the ones submitted originally. Okay, hold just. So I take it then where the palmetto and the oaks are, that's all what we're discussing right there, the greenway.
That is the greenway, yes, sir.
And the gravelled part of that driveway, is that additional, is that the lot line theoretically along there?
Lot line is basically the beginning of the vegetation. So the driveway is not directly on the lot line. We do have a few feet to the right of that driveway that is personal property.
Okay.
Can I follow up with the question on HOA? Apparently, your rules or regulations don't require a response from the HOA. Can the board require HOA approval? Authorization to proceed, maybe is a better way to say it.
Sure, you could make that a condition. So generally, HOAs, any of your HOAs, any sort of covenants, those are all civil, private civil matters beyond our purview. I suppose you could put a condition upon that. It would just be a matter of finding out exactly how y'all would want that confirmed. Because once again, we don't get involved in that, so.
Right.
It would, I don't know if it would have them required turn in a letter from them at the time of permitting or something like that.
Yeah, you probably understand what I'm getting at. If this is
Yeah.
the first one, there might be a number of requests, and then HOA gets tired of it and says no to someone. Now they're not being fair and equitable to their own members. But I would think that a simple letter from the HOA president saying, you know, we've been contacted, we understand what he's asking for, and we don't have a problem with that, would certainly, in my estimation, give another, it'd be a comfort zone that HOA is saying it's fine. And I understand that HOA could tell you no, even if we say go, and you're still stuck.
Right.
I just feel better if I know that HOA knows it's coming.
Okay. So basically asking permission before we go through the plan set, is that what you're looking for?
Yeah.
Okay.
Yeah, even though we don't necessarily, I mean, it's out of order maybe for one of us, but it gives me a comfort zone.
Okay.
The existing garage, I guess that'll be turned into a room then?
There's no plans to convert it into a living space at this time.
Will it be also a garage?
A storage area, is that correct? Yes.
So in other words, you'll use that for all the odds and ends we all collect, I guess,
Correct.
in our lives. And then the actual carporting will take place in the new facility.
Correct.
hence part of the problem. I mean, why we're here, for y'all to make this decision. Always remember, staffs, look at the criteria as black and white. Minimum necessary, I mean, they could sell the house tomorrow. Somebody with less stuff could move in and not need the extra garage. So we have to look at it strictly as, permanent physical hardship on the land. So
Can you have,
we bring it to y'all.
can you have two garages like that?
Sure, but remember, a variance requires some sort of special physical hardship on the land. It's based on needs because of that, not wants.
Excuse me. With that being said, could you explain the hardship that's on the land? I mean, since you live there, right?
I'm the acting agent.
Okay.
The owners are
Okay.
here to mow that.
So maybe they can clarify the hardship that's going on.
As I said earlier, this plot of land was purchased and the home was built on it. So in terms of the land itself, I can't say that it's a hardship on the land, but in terms of our request, the only thing we're asking for is not going to adversely affect the plan for the plot to start with. It's still going to just be a single-family home. It's just going to have a garage that's big enough I can put my vehicle in it. I never thought about a garage that wouldn't accommodate the vehicles, but literally, her car, if you look at the picture, her car is out there not because it's just out there and she just came home and put it in the driveway. You can't get it in the garage, not safely, because they built the garage too small. And I have personally, I've put her car in the garage with the other car. You can't open the door. So it's like, it's for all practical purposes, it's a one-car garage. And so I can't challenge the fact that the house, as it is, doesn't violate the land use per se, but I don't think it would violate the land use with the add-on of a different, bigger garage either. So I don't know how to express that other than to say we're kind of in a bind. We don't have any storage for stuff, and we can't put a building in the back to put stuff in. We don't have an attic space. We're kind of stuck. And asking for this variance would not in any way that I know of adversely impact either the land use as it was designed to start with or any of the neighborhood. So I don't know whether I don't know any other way to say it, but like I say, the reason our car's out there is because you can't get it in there. And I think that's just short-sightedness on the part of the initial builder that we're just trying to alleviate.
And if this structure was able to be detached, which of course we have the HOA restrictions that don't allow us to, but by the land development code, we could build this detached, would allow us to go up to 5 feet of the property line off the rear and off the side. And Caleb, I don't know if you can apply for an administrative variance on a detached structure, but if I could, we would be approved to go up to 4 feet. So we're literally talking 9 more inches over what would be approved if this wasn't if this was not attached to the home. A detached structure, I could build it all the way up to 4 foot from the line. But the HOA requires us to attach it to the house, which is why we're here.
So I heard you say that, I've heard that the HOA wouldn't have a problem with your application building within 3.2 feet of the lot line, but they do have a problem with you building a detached garage that's 5 feet off the property line.
Correct. They honestly don't care where it is on the property, it's just gotta be attached.
Yeah.
And once we attach it, it becomes
It's
part of the
defined
primary
as something
structure. It's
differently.
Yeah.
Yeah,
something that the HOA put in their covenants that does not jive with the county, and it just, I'm sure, I know it's been a problem for me on other projects.
Yeah.
Every time we build out there, we wanna build one of these things, this becomes a problem.
Again, I think the reason for them not to want a detached, I think the reason they don't want a detached something is because they don't want people to go out and buy a building from Lowe's, and put it in the backyard to put the lawnmowers and stuff like that in. We had the same issue in the place that we lived before. You had a single structure on the lot, and it had to be pre-approved by the HOA, and you couldn't put anything else on the lot. And so it's not an uncommon reality, because they're trying to avoid the addition of stuff that doesn't match up with the primary structure. So they want a primary structure that's cohesive and nothing else.
And the reason we are asking to go to 3 is to get the width that we need for a garage in order to create something that's A, structurally sound, and B, big enough to put a garage door that can bring 2 cars into it. So a 2-car garage door at a minimum is 16 feet, which is tight to pull 2 cars into anyway, or an 18-foot door, but we still need a couple feet on each side of that to structurally make this building stand, which is why we're looking at going to the 3 feet.
I always think when I hear Drew say it's, the county's black and white, the Board of Adjustment's gray, which to me, that's his interpretation of saying, hey, we ought to do this.
I always throw the word staff in there.
Yeah.
Any closing statement by staff? It's probably not necessary. It'd be-
No, I would just say, you know, like you just said, it is fairly, it's black and white for us. That's why we come to these things. I would say, again, to benefit the applicant, it doesn't appear to be injurious to any other neighbors or anything like that, so.
Your thoughts are good. Does the applicant want to do a closing statement? I think you've done a good job of presenting.
I would say that we do intend for it to be a cohesive thing as far as, you know, we have a brick home, we have everything matching up to it. I guess probably my final word is please.
If the board wanted to, and I would defer to Mr. Homer for his guidance, if you needed some contingency upon the HOA, would apparently be the one that's going to be affected the most with the private greenway. There's something that would be needed from them prior to issuance of a permit for the addition. Put that into the motion of approval or denial, whatever it may be.
Okay.
If I might add, I think that makes sense. Instead of asking for a letter or some kind of type of representation from the HOA beforehand, because
That could be a condition.
Yeah.
Okay, board members, any questions? Chair will now entertain a motion regarding this item. If your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's finding of fact, please go through all the criteria and address each one specifically as why do you not concur with staff's findings. Do we have a motion?
I'll make a motion. I move that we approve the applicant's request for a setback adjustment with the stipulation that we receive a letter from the HOA indicating that the structure would be acceptable to them.
And we would add that we deny staff's findings of fact.
Yes.
Up front, and then as your motion stated. Okay, we have
Correct.
have a motion by Marty. Do we have a second? If we do not have a second, the motion will die. Okay, call for another motion.
I'll make a motion that we agree with staff's finding of fact. Unfortunately, I do not see a hardship on this case, and I would have to agree with staff's finding.
Second that.
We have a motion by Jennifer, a second by Willie, that we accept staff's findings of fact and deny the motion. Is there any discussion? Seeing none, those in favor signify by raising your right hand. Those opposed? Passes 4-1. All right, our next meeting is December 15th, 2021. December 15th, be ready for big fruit cake from the staff for us.
Yes, we will have one variance and 2 conditional uses as of right now.
There's no further business. We stand adjourned.